As the Mental Health Act of 1990 states, mental illness is defined as a condition characterized by the presence of symptoms such as delusions, hallucinations, serious disorder of thought form, a severe disturbance of mood, or sustained or repeated irrational behavior which seriously impairs either temporarily or permanently the mental functioning of a person. If the mental health of an individual is relevant to a case, a competency test is done to assess the individual and ensure that they are fit for trial. If the individual does not agree with the ruling done by the court, they are allowed to have a third-party opinion taken. Based on that professionals, the new ruling stands, and the court will continue the case without objection. Mental health cases are becoming more relevant in today's society, and so more laws are being put into place. The Mental Health Parity or Equal Coverage Laws prohibits insurers and health service providers from discriminating against patients that are considered to have mental health problems instead of physical problems. While the minimum mandated mental health benefit laws require some level of coverage to be provided to those with mental health issues. One of the first cases dealing with mental illness occurred in 1990 in the case of Zinnerman versus Birch. The case held that the U.S. Constitution prohibits the voluntary treatment of patients that are incapable of informed consent and in reality do not know what they are doing. This case tackled the issue of consent in those with mental health problems. In 1997, the case of Kansas versus Hendricks took into account the behavior of the defendant. It wasn't until 2002, in the case of Kansas versus Crane, where the original decision was modified. This second case established that there must be sufficient proof that the individual has trouble controlling their behavior due to their mental illness. This case ensured that wrongful detainment would not occur. In 2003, the case of Sell versus the U.S. ruled on the dangerousness of an individual. This case ruled that the medications used to ensure that an individual is fit for trial needed to be regulated so that they would not interfere with the competence of an individual involved in the trial. The individual in this trial did refuse to use the medications that would make him competent, and therefore the trial itself was skewed. In accordance with HIPAA laws, mental health is handled differently than many other conditions because of its sensitivity. HIPAA allows for more open communication with the family and friends or those close to the patient itself based on the fact that it deals with the mind. When the patient cannot be deemed competent enough to pass information on to and expect a reasonable response, the family is then necessary to pass on said information. Whether the patient is an adult or a minor, the family still has the right to look at the medical records of the patient. The family has a right to be told when the patient is refusing medication or treatments. The treating physician can also contact outside authorities if the patient is deemed a threat to himself or others. In a case like this, the family is also still involved. The privacy rule of HIPAA allows that psychotherapy notes are given stricter regulation based on the content of those notes. The notes contain sensitive information which is not essential in the treatment, payment, or healthcare services of the patient itself. Therefore, the notes cannot be disclosed unless mandated by law concerning the reporting of abuse and threats made by the patient being evaluated.
Health insurance is so important to everyone, and without it, a patient might not be able to receive the treatment they require. This is especially true in the treatment of mentally ill patients, as sometimes the treatments they require are not covered or are poorly covered by their health insurance companies. Most health insurance plans have what is called a parity. This is to help ensure that the coverage of mental health treatment is equal to the treatment of physical health. If a patient would be covered with unlimited visits for physical health issues, then they should be covered with unlimited visits for mental health issues. However, this does not mean that the coverage will be good, only that there will be coverage for such treatments. Nearly all insurance plans must follow the parity guidelines, with the exception of Medicare, Medicaid, and some other plans which have been grandfathered in. Parities overall cost more to cover, meaning that some insurance plans may try to violate some of the guidelines. There are many signs of these violations, such as denials of mental health services because they are deemed not medically necessary. If someone believes their insurance is violating parity guidelines, they can contact their insurance company or access the U.S. Department for Labor webpage for more information.
Hi, my name is Antonella. I'm a registered nurse. I've been a nurse for 3 years now. Currently, I'm working in an oncology unit, but prior to that, I've had experience in critical care, med-surg, mental health, pediatrics, and geriatrics.
When is it appropriate to disclose information to a patient's parents regarding their health?
In regards to HIPAA, the law sees a patient as an adult if they're older than 18 years old. If the patient is under the age of 18, then we would consult with their either their parents or their legal guardian. But if the patient is older than 18 years old, they would be able to make decisions for themselves if they have the capacity to.
Let's say the patient is 19 and has schizophrenia or another developmental disorder. What are the rules and regulations then, and what happens?
In regards to that situation, because the patient is over the age of 18, they would be able to make decisions for themselves, but because they have schizophrenia or let's say Down syndrome, where the patient would not be able to make sound decisions for themselves, they would not be able to decide their healthcare regimen. For example, let's say the patient required medical testing. Typically, any patient in the hospital can refuse any medical testing. They even have the right to go AMA against medical advice, which means that they are allowed to leave the hospital against medical advice. But because of a condition such as schizophrenia, or if a patient has Down syndrome, they would not be able to make a sound decision for themselves. That also falls into informed consent. The patient must be alert and oriented ×4, which means to themselves. For example, I know that my name is Antonella Termini. Time, I know that the date is July 1st, which is a Saturday. Place, I know that right now I'm in my home. And situation, I know that I am doing a interview right now for a legal aspects course. If the patient is not alert and oriented ×4, or if there's periods of confusion and forgetfulness, at that point we would move over to the healthcare proxy or whoever is in charge of this person's care, and we would consult with them.
Moving on, when is it okay to disregard the rules of HIPAA?
Typically in the healthcare setting, we really try to stick to HIPAA just because it is extremely important confidentiality, and it's that caregiver to patient trust and relationship. There are situations though where HIPAA can be violated. In regards to that, it would be if a patient is a danger to themselves or to others. At that point, we would not be disclosing medical information to embarrass the patient or to commit slander against them. At that point, it would just be strictly because of the safety to themselves or to others. So, for example, in my psychiatric rotation, my group actually was able to go to a mental health court because a patient was pulled off the streets who had schizophrenia, and they tried to admit him into the psychiatric unit, and by court mandate they were able to involuntarily hold him for 72 hours. After the 72 hours were up, they They took the patient to court, and at that point, a judge decided what the plan of care should be. And actually, that patient ended up going back to the psychiatric unit for further treatment inpatient, and then was mandated to do up to 6 months outpatient. And at that point, the healthcare providers would follow up with him.
In dealing with healthcare law, as with law in general, the topic of subpoenas arises. In general, subpoenas are used to summon documents, people, witnesses, evidence, and other things. Generally, such items will be used specifically in a court case or court hearing. When examining mental illness in healthcare law, it is important to be aware of the function of subpoenas duces tecum, otherwise understood as the mandatory forfeiture of requested documents. In this case, the summoning of mental health history records, which is easier issued than carried out. On average, mental health records are protected under state law and HIPAA. That is to say, most often, records cannot be disclosed without consent of the patient/individual, the person's legal guardian, or the person in charge of the patient's mental health and medical decisions. However, at times, subpoenas possess more power and can execute the request without consent and without being prohibited by law. Usually, this occurs during court order or administrative tribunal, criminal proceeding, or law enforcement request, or to protect public welfare. Though, even in these instances, there are still protections on how much or what part of the records can be released and what precautions are taken to maintain privacy. Should a mental health record be requested and disclosed to the party requesting them, while legal requirements are met, there still remains the issues of ethicality. Exposure of one's mental health records can be seen as invasive, embarrassing, and even publicly damaging, especially when courts do not seal the documents and they become more easily accessible to others. That is part of the reason why healthcare is focused on confidentiality and so strictly adheres to confidentiality and consent policies. Disclosing of mental health documents often is controversial because where it may be legally correct, it is ethically wrong and vice versa. For example, if a patient goes to mental health counseling and divulges that they are currently and intend to continue harming someone, there's a legal and ethical duty of the therapist to report the crime and to help those being harmed, while eliminating the harmful tendencies from the patient. In a way, this could be called ethical exposure as well as a very appropriate circumstance to subpoena mental health records later on. While it has been discussed how mental health factors into subpoenas and the legal ethical dealings of this, it has not been mentioned how mental health factors into court hearings. As subpoenas are oftentimes used to summon information for court hearings, this is an important topic of mental health in regards to healthcare law. Thinking about having to grant access to one's mental health records in general seems fear-inducing, but having such documents openly discussed in court is even more troubling. However, this is only done, like with previous mentioned instances, when definitely necessary. Examples of this include in a criminal proceeding, to protect the patient's own health and safety in relation to substance abuse, or to commit someone to treatment or psychiatric hold if they are deemed incapable of making their own suitable mental health decisions. When this is done, the documents are discussed among a small group of necessary individuals and only pertinent information is viewed. The trial of Colorado shooter James Holmes, while certainly not private in nature, is a relevant example of how mental health/illness factors into a court hearing. Holmes, in trying to avoid harsher penalties for his actions, pled not guilty by reason of insanity. Because Holmes and his defense made it abundantly clear that Holmes possessed a mental illness, and this was a criminal proceeding, Holmes's mental illness records were subpoenaed by court, examined in court, and his mental health state was examined and tested by a psychologist. Though it was a rather public disclosure of mental health, He waived his consent and still, even then, was granted some confidentiality in this very public hearing.
Hospitals and health systems are responsible for protecting the privacy and confidentiality of their patients and patient information. HIPAA protects the privacy of protected health information and personally identifiable information. It is illegal to share any of this information with an unauthorized person or facility without the patient's consent. However, with regards to criminal activity, a healthcare entity may share HIPAA-protected information with law enforcement personnel for the safety of the individual and the public. These disclosures may be made in good faith when there is suspicion that there has been a crime committed by a mentally ill person on the premise of the healthcare entity, or when there is reason to believe that law enforcement would be able to prevent or lessen a serious threat to the individual or the public. There are not only reporting requirements for crimes committed by mentally ill persons, but also ones for crimes committed against them. The Willowbrook State School committed many crimes against the patients who resided there. The institution was extremely overcrowded with no hygiene. Some patients were sleeping on floors and living in their own filth, while others were being used in experiments for hepatitis testing. The institution finally closed its doors after reporter Geraldo Rivera broke the story and exposed the institution for its horrible conditions and its treatment of patients. Healthcare professionals also have moral and ethical obligations to their patients that they feel they must uphold. Physicians, in some circumstances, want to follow the law, but also want to protect their patients, knowing that they might not be trusted by their patients if they break confidentiality. When patients commit crimes, there becomes a big question of whether they be punished with jail time or be treated for their illness. The public often has a hard time acknowledging the fact that mentally ill patients can be hospitalized, treated, and released a relatively short time after committing a crime. The decision of punishment or treatment can be very hard and is not so black and white, as every case is different.